be talking about psychedelic coaching and the law, a guide to ethical practice. That will be our emphasis and our focus today. This is brought to you by the Psychedelic Coaching Institute. So I know many of you, as Paul Austin from Third Wave, we also, as many of you are aware, now have a training program through the Psychedelic Coaching Institute. A lot of our alumni are joining us, and Barine is also a faculty in our training program. And I met Barine through her colleague Josh Capel. Josh and I started the Microdosing Collective together, a 501c3 nonprofit to legalize microdosing. And Barine has been great as a guest faculty. As you can imagine, there are a lot of coaches and practitioners who are coming into the psychedelic space who have a lot of questions. And I'm sure many of you are in this same area, have a lot of questions about what can I do in this space? What is legally protected fully? What is quasi-legal in terms of there's precedent to have some level of protection, and what isn't so legal? In terms of what people do, and there's not really any enforcement around, and what's definitely illegal. And so there's a lot of nuance in this space, especially as states like Colorado and Oregon have legalized psychedelics, and many other states are now considering it. New Mexico also has medicalized psilocybin. There are several other states that have bills available. But Barine, I just first want to welcome you to the floor. Thank you for joining us.
Thank you for having me. I love doing this stuff with your program. So you guys always have the best cohorts. So it's great to be here.
I'm so glad to hear that. So just a little bit more about myself, and then I'll also share a little bit more about Barine. Like I said, I founded Third Wave in 2015. We started doing these training cohorts for practitioners in 2021. And we opened up the Psychedelic Coaching Institute in 2023. And then we also do quite a few webinars and public education through the Microdosing Collective. I published a book a couple years ago, Mastering Microdosing, which you can find on Amazon if you're interested. And my work has been featured in many places. Barine is a counsel in Vicente's Denver office and a leading member of the firm Psychedelics and Emerging Therapies Practice Group. Her respect for plant medicine led to an internship in psilocybin studies at Johns Hopkins School of Medicine, where firsthand experience as a guide gave her clear insights into the benefits and pitfalls of psychedelic work. So that's pretty cool, Barine. You're not only a lawyer, but you've actually been really in the depths with people as they've navigated some of this work.
Yeah, I was planning on leaving law and joining Johns Hopkins and their crew because I was so moved by the research there. But then I got married, moved out to Colorado, did a whole bunch of other stuff, and kind of punted on going back for a PhD. And I'm actually really happy I did. When I came back to law, I found Vicente, and they're so aligned with my values, and there is such an activism spirit at the firm, starting with cannabis before psychedelics was a real movement here. That anyway, ending up back in law was the right move, but it was very tempting to sort of move over to the research side of things.
Yeah, and part of what I think we'll talk about as well today is, being, especially back in the day, right? I imagine this happened some time ago when you were helping to guide some of the therapeutic experiences. There really was no career path for those who were exploring this work. There's always been the anticipation that this would open up eventually, but I imagine at that point in time, it may have been pretty difficult to see how you could even make a career out of doing work like this.
Yeah, it's definitely true. This was, I guess, around 2010. I'm really bad with dates, but it was like early in 2000s, and there were career paths for researchers, and that's what was really up there, but nothing like the sort of psychedelic renaissance we've seen was anticipated. And I think researchers like Roland Griffiths and Matt Johnson and other folks at Johns Hopkins and at other universities sort of paved the way by letting this work become legitimized first in a research context. The conversation was so careful and so conservative back then compared to what we have now. It was just so different in terms of what people would say, what people would admit to researching, what people would admit to being interested in. So we're very lucky in terms of how it's proceeded and opened up. It was very different back then.
And Colorado really has been at the center point of that. I mean, starting with the decriminalization of psilocybin in the city of Denver, I believe that was in 2019, 2018.
Yeah, that sounds right. Like that.
And that was pre-COVID.
Yeah,
and it was pre-COVID. And then we had Oregon that legalized in the election of 2020, which was finally implemented in early 2023. And then Colorado legalized in 2022. with the Natural Medicine Health Act, and now some of the structure of that is really starting to go into place outside of just general decrim for these plant medicines. So we'll really dive into the nuance of that today. We're going to cover what's actually legal today. We'll talk about what are some of the biggest pitfalls that practitioners have to navigate, how we can communicate and talk about our practice, what are the things that we can do to protect our practice, waivers, disclaimers, and agreements, how we navigate cross-state and online practice, and more. We have only an hour. This could probably, if we went into real super deep depth on everything, it could probably take multiple hours. That's why we have Barine come in as a guest faculty in our practitioner training program to go into even more depth and detail around these things. And we will have a little bit of time for Q&A. So Barine, to kick it off, we've already done this a little bit, but I'd love if you could just ground a little bit in sort of who you are and what you're doing with Vicente in particular when it comes to psychedelic law, policy, and ethics.
Sure. My name is Barine Majewska. I'm counsel at Vicente. Vicente is a nationwide firm. We do stuff all over the country. Their background started in cannabis law, and they were really deeply involved in the cannabis legalization movement in many, many states. We still do a ton of cannabis work. A few years back, I've been at Vicente for 9 years, I think now. A few years back, when the psychedelic movement really started to get going, we started a psychedelic practice group focused just on psychedelic work. And Josh Capel, who is one of the founding partners of the firm and who Paul knows, maybe some of you guys know, and I, we co-lead that practice group. And our firm has continued to be really involved in the legalization and decrim efforts for psilocybin and other psychedelics. Prop 122 in Colorado, Josh wrote a lot of it. As you know, that was the ballot measure that got voted in by Colorado voters. It then evolved and got implemented by the Senate bill. We can talk about all of that later. But the Colorado program that exists right now is based off of Prop 122 as it was implemented by the Senate bill. So we were very involved in the language of that actual law, and then have been, both Josh and I and others at the firm have been involved in the day-to-day sort of writing of the rules and regulations for the regulated piece, and have been working with clients working in Colorado and in other states in sort of harm reduction models, in regulated models, in personal use in Colorado, folks doing international work that are bringing US citizens over there. We'll consult with them. So we do a lot of this work day in and day out. It's a lot of fun. I think that covers it. Yeah, I was at Johns Hopkins on their psilocybin studies. I was a research assistant there. That was incredibly eye-opening and interesting. I have a long history and respect for plant medicines, so I already went into that program with a lot of my own opinions, but seeing it used in a clinical setting by folks that were super thoughtful, super intelligent, very high integrity, it was really interesting. It was really eye-opening. I think I lost some of whatever naivete I still had about psychedelics at that point, was sort of gone by the end of that. And not in a bad way, just really seeing both its power and its downsides when you try to see a lot of people and work with a lot of people. And I was on primarily their spiritual experiences study. So it was pre-screened for people who were psychedelic naive and for people without serious mental health or physical health conditions. So we were getting like a pretty healthy cohort of people that were just exploring psilocybin for spiritual experiences. And even there, the kinds of problems that would come up or how unpredictable they would be was just really eye-opening and really interesting for me to see. And I think that's informed a lot of how I think about this stuff. I think I would be coming at this differently as a lawyer if I hadn't been in that context. So yeah, that's some of my history.
Beautiful. And that's, I think, helpful starting context, because Vicente really has been at the front lines of developing psychedelic policy. Colorado, a lot of people would say the policy that they developed is sort of a step beyond what was initially pioneered in Oregon for various reasons, some of which we will touch on today. But let's start with the big picture, right? Because the field of psychedelic guidance, coaching, therapy, facilitation is growing incredibly fast, often faster than the rules that define it. Could you just give us a clear overview of the current legal landscape, the general status of key substances like psilocybin, and just kind of lay the sort of groundwork for policy specific to the United States?
Yeah, totally. Let me start by saying nothing here. I'm going to start super lawyerly. Nothing here is legal advice. It's an attempt at educating in a very short period of time. Usually when I do these, I end up just like fire hosing everyone and then feeling bad about it. So it's an accelerated and info dump that will hopefully get you guys thinking about some issues that maybe you haven't been thinking about. But if you want to go practice in any state, you want to set up your practice in the safest way possible, please consult with a lawyer. It can be us. We do free 15-minute consults. If you don't need to become a client, we'll let you know that in the first 15 minutes. It can be others. There are other good psychedelic law firms there, but please consult with someone who knows what they're doing about your specific case, and don't just run, from what you hear today, because it is complicated and it is nuanced. I'm going to try to make a bunch of distinctions because I know that with anything that's this complicated, we have 50 states, we have a federal program, everything is sort of nuanced. I'm going to try to make distinctions that even some of my more experienced clients will come in and they won't know some of these things. So I might occasionally bore you. I might occasionally info dump, and hopefully somewhere in there, this will be really useful. One thing to notice is ketamine is its own beast. So ketamine is not covered by any of the stuff we're talking about here. It's not Schedule 1, it's Schedule 3. It has an understood medical purpose. Even before any decrim or legalization movements, ketamine was under its own structure federally. So it needed to be appropriately prescribed. But if appropriately prescribed, it could be used in different ways. It's being used off-label. We're not going to talk about ketamine here, but it's useful to kind of keep ketamine in its own bucket. And if ketamine is something you're interested in working with, it needs to be treated differently from like a legal business standpoint than the other medicines we're talking about here. Everything else we're talking about here today is federally illegal. So it's really important to remember that. It's a little bit like, it's a lot like the early days of cannabis in the sense that we have a federally legal substance, federally Schedule 1 controlled substance. And then we have state frameworks that are starting to first decriminalize it, is what we were seeing earlier, and now actually legalize it in Oregon, Colorado, and recently New Mexico. And so it's important to remember that whatever we say here, there is sort of this risk, this unquantifiable risk of federal illegality looming over us. Obviously, none of us thinks that the federal government is going to show up tomorrow and shut everything down, right? There's a tremendous amount of business operating here. So there's a lot of sense, like we had in cannabis, that this is probably that the federal government is going to respect state models and state movements around legalization, but we don't know that for sure. In cannabis, we had something called a Cole memo, which came down from the Attorney General's office at the federal level saying, hey, we're not going to go after you for cannabis related crimes if you're complying with your state laws. We don't have a Cole memo for psychedelics. And that's just important to notice, right? Just important to know that that's just the water we're in right now. And that may change at some point. And I hope it does. But that's the background. So important to remember that. Let me also talk briefly about decriminalization and legalization. These words get thrown around a lot. I'm going to focus today more on the actual legalization models for the states, and decrim models also exist. They exist locally. And they've, like Paul was saying, in Denver, right? We had a big movement there long before Prop 122 actually came along. Sometimes people use the word decrim politically because it's like safer sounding and less controversial than legalization. But when you're talking about a state framework or a local framework, it's important to understand what's actually a decrim and what's actually a legalization. I would argue that Oregon, Colorado, and now New Mexico are actually legalization frameworks in the state, no matter what we call them politically to get them passed or whatever. They really are creating legal models of use in a state, and often state regulated. In all three, actually, there is a state regulated program. Decrim models are usually things like that either make possession or use of a substance the lowest law enforcement priority. So for a locality or sometimes for a state, they're proposed. It'll tell the law enforcement, don't prioritize, for example, psilocybin crimes. Psilocybin crimes may still be crimes, but don't prosecute them, don't arrest people, don't go after them hard. And they'll say this in different language. Or they will actually reduce the criminal penalties involved. So even though they're called decrims, usually they stay a crime. They're just not a crime in practicality. Like they're not enforced, or even if they are enforced, the penalties you get won't be that great. But decrim models are different than actual state legalization models, which is what we're going to focus on a little bit more today. And the only three states that have done this legalization, like I've mentioned, is Oregon first, Colorado, and now New Mexico, although that model is not yet operational. It's not really kicked in. I think they're going to be working on those regs until 2028. So, and very briefly, so Oregon was the first, sort of the front runner there, and they have a state regulated program. It's only for psilocybin, and it's only for state licensed facilitators go and they work with state licensed medicine. They work in specific locations and they give people psilocybin in these sort of prescribed contexts. That's Oregon, right? Colorado came along and it had a very similar psilocybin model. There are important differences we will probably get to today, but it also has a state regulated model, right? So again, this is like going to the store and buying milk, right? In some sense, the facilitator is licensed. They have to have certain training to get that license. The psilocybin is in a state licensed supply chain. So it's grown by licensed cultivators. It's packaged and manufactured by state licensed manufacturers. How it's transported is state licensed. The sessions need to be done almost entirely, with some narrow exceptions, at state licensed healing centers. So the whole protocol is overseen by the state and regulated by two regulatory agencies, primarily in Colorado. What is interesting about Colorado is that we also have a personal use program, and that state regulated program, like in Colorado, like Oregon, is also psilocybin only. However, in Colorado, we also have what's known as the personal use program. It's called personal use. Sometimes my clients are confused about why it's called that. It's because if you look at Senate Bill 23290, and if any of you guys are legal nerds and you actually want to go read it, Prop 122 is what was voted in. Senate Bill 23-290 is what the Senate wrote to actually implement the ballot measure that the voters voted in. So we didn't get exactly what was voted in. We got something pretty close to it. But Senate Bill 23-290 is what you want to read if you actually want to see what the law is in Colorado. In that, there's the state regulated program, which is one thing kind of off on its own. And then there's this personal use definition. And what that does is it allows people legally to have a personal use amount of these medicines. And these medicines are psilocybin, but it's also DMT. It's also mescaline excluding peyote. And it's also ibogaine, but you cannot share ibogaine, which ends up being very important for the kind of work we're talking about here. So bracket ibogaine off as a different creature. And it allowed people to possess personal use amounts, whatever that is. That's not defined. It's not quantified, but personal use amounts of these medicines. And importantly for this conversation, it also allowed people to share personal use amounts for free as a gift. It did not allow sales of any of these, right? So you can't sell DMT legally in Colorado. I hear stuff about this all the time. You cannot sell mescaline. You cannot sell psilocybin unless you're in the regulated program. But under this personal use definition, it also made it permissible to be compensated for your time in providing bona fide harm reduction and support services together with the sharing of the medicine. So you can't get paid for the medicine that you're sharing, but you can get paid for your time if that time constitutes bona fide harm reduction and support services. There's a lot of nuance here. There's some more details. You can't call yourself a facilitator. That word is taken by the regulated side. So you can only call yourself that if you have a license. You can't advertise. We might get to what those things mean. So there's a very rough view of the personal use protections, and you have to comply with them for what you're doing to be legal. But that's why it's called personal use. And so a lot of folks will guide people and provide these bona fide harm reduction and support services together with medicine that they're sharing with their clients under this personal use model. And they do it without getting a license. And that's important. And Colorado is the only state right now that has a personal use program. It's a bit controversial. Some people, especially on the regulated side, don't love that it exists in parallel to the regulated model. Again, lots of nuance here. We're going to see more discussions about this in Colorado in the upcoming legislative session. And as the advisory board starts to talk to these regulatory agencies, they're going to have to really understand how personal use plays with the regulated model now that our regulations are up and running. But that's important for you guys to know because it's a unique feature of Colorado. I hope other states adopt it. We haven't seen other states adopt this personal use piece yet. And then we have New Mexico. It's a regulated program closer to Oregon. It's a little bit different in that it's medicalized. You need to have certain conditions, certain mental health conditions to go receive those services. But otherwise, it's reasonably similar. It's psilocybin only. It's by licensed facilitators in licensed locations. What those are not known yet. But it's a similar model with a slightly more medicalized spin than Oregon or Colorado.
All right, cool. So this is a great landscape. And I think the first question that's coming up to dive a little bit deeper in is really specific to psychedelic coaching. rather than strictly clinical and therapeutic use. And the reason I'm making this distinction is because I think a lot of the legal, clinical, and therapeutic use right now is focused on ketamine. And as we talked about, that ketamine is like a whole separate sort of conversation and topic. So to really focus on psychedelic coaching, non-clinical work like preparation, integration, and harm reduction, it's very clear that what is legal in Colorado is different than what would be legal in, let's say, California, as an example, or New York, or Texas, or really any other state in the U.S. right now. So could you talk through and clarify maybe a little bit of that distinction and difference in terms of how does a practitioner operate responsibly within existing frameworks as a psychedelic coach, specific to Colorado, and then specific to basically every other jurisdiction in the United States?
Yeah, great question. I'm actually going to answer your question in reverse. So I'm going to answer what you said first. Like, what if you're in not one of these three states? You're not in Oregon, Colorado, or New Mexico. You're somewhere else. Or you're in Oregon, Colorado, and New Mexico, and you're not trying to operate within the models that they have of legalization. Okay, what can you do? Preparation. Let's actually start with integration. That's the easy one. Integration is probably okay. Someone has already tripped. They've already done a journey. They come to you. They need help integrating, right? If all you're doing is helping them integrate, it's probably okay everywhere. If you have a license, if you are a licensed professional therapist, social worker, psychiatrist, something, what that integration looks like needs to fit your scope of practice. We'll touch on that more later because that gets trickier with other pieces. But generally, integration is probably okay. Preparation. Interesting question. Maybe okay. Preparation in terms of like talking to someone, helping educate them about the nature of psychedelics, pointing them at scientific research out there about contraindications. Hey, you probably don't want to take this if you're on SSRI, if you're on antipsychotic, these might be the effects. That kind of preparation, probably okay. If your preparation starts to turn into encouragement, or telling someone that they should do it, or greenlighting someone saying, you know what, you're great, you are cleared, you can go do as much ayahuasca as you want, probably not okay. But a very general prep might be okay. All right, harm reduction. Actually, let me say one more thing about prep. If your preparation involves, and by the way, if you go to Joe Smith down the road, he will give you the best psilocybin in town, almost definitely not okay. And we're going to hopefully, Paul, I think this is a question you and I wanted to cover. Hopefully at the end, we'll get to, how do people get medicine, which will become very relevant due to the bad news I'm about to say next. Okay. Harm reduction. Very interesting, right? This language comes from the opioid epidemic. I don't love it. A lot of people don't love it for psychedelics, right? Because we don't have the same type of harms. We're not doing the same type of reduction. In fact, many times we're hoping to enhance or benefit someone further by doing a medicine that we already think is hopefully beneficial for most people many of the times. But this language is out there. It's in the culture. It's in legal precedent. And the idea is that someone's going to do the drug anyway, right? So if you're operating in a harm reduction model, you're not trying to encourage someone or tell them that psychedelic medicine or some plant medicine is good for them, or that they should go do it, or they should go do it instead of doing their psychiatric meds or whatever. Even if you believe that's true, that's not the harm reduction model. The harm reduction model is someone's going to do it anyway. I'm going to stay here and keep them safe while they do it. And it's a well understood model. Harm reduction is probably okay in states where we don't have a legal framework if, and this is a big if you don't provide the medicine. If you provide the medicine, then you are probably in the realm of some sort of drug trafficking or aiding and abetting someone in obtaining a controlled substance. You're not in good territory. So you don't want to provide the medicine. If you don't want to provide the medicine and you can kind of set up the communication, your documentation, like it's really this way that someone was going to do this medicine and they came to you and you're qualified and you're trained and you sat with them and held space and you made sure they didn't run out the front door or, eat something they shouldn't or whatever, then it's probably okay. It's not tested, right? So if a criminal case were brought on this, I would be a bit surprised, but it could happen and we don't know the outcome. But if you're not providing the medicine, that's probably the safest way to engage in what we're calling harm reduction or psychedelic coaching in a state that doesn't have a legal framework. This always raises the question of like, well, then how are people going to get the medicine? And if it's okay with you, Paul, I'll punt that to a little bit later.
Perfect. We can put that. Yeah.
Okay. Sounds good.
No problem. I mean, I will say on that note, like I have a lot of, just as a brief example, medical doctors who are friends of mine who say, I have clients come in who, I think might be able to benefit from microdosing as an example. And I obviously can't point them in the direction of, tell them that they should microdose or encourage them to microdose. But what people will do is often say, go learn more about it on Third Wave. And so they'll point people and say, just go to this educational platform, go to Third Wave and sort of learn about it from there. So anyway, but we can come back to the sourcing question.
Yeah, that's great. Those doctors are doing it right, just to say it briefly.
Yeah. Okay, continue though, please.
Where was I? So yeah, that's preparation, integration, harm reduction, right? Those are kind of the buckets, kind of from lowest to highest risk. Integration is almost always safe. Prep is safe if you know what you're doing and you're not encouraging. Harm reduction is probably safe as long as you're doing something that is actually harm reduction and not like a hidden form of encouragement. And again, with the big if you're not providing the medicine, which of course raises other practical risks instead of legal risks. If someone is coming to you with their own medicine, where did they get it? Did they get it from Instagram? Is it mixed with an MAO inhibitor, which is one of my least favorite stories of someone buying mushrooms from Instagram? All of those sales are illegal, by the way. I think everyone on this webinar probably knows this, but it doesn't matter if they're selling them in downtown Denver, which they are, or on Instagram, which they are. They're all illegal. The fact that they haven't been shut down yet doesn't mean it's legal. It also doesn't mean you won't get in trouble if you start doing that. It also doesn't mean that any of these places will continue to be operating tomorrow morning or a week from now or a month from now when the political climate shifts, if the political climate shifts. So all of those sales are illegal. And if your client runs out and gets it, you don't always know what they're taking, which is a problem for you as their guide or their facilitator. So worth flagging as a issue to discuss.
Well, and Barine, we're going a little off piece now and off track based on the sort of agenda that we put together prior, but here we are. Because a lot of people think, there was even a question in the Q&A, like, how are people selling these psilocybin microdoses all over the place? And this is a really common question that we get at Third Wave as well. I mean, how is it that there are so many, places in Denver and in New York and in LA and, websites online that are just actively and openly selling Schedule I substances like psilocybin and mostly psilocybin, but like how is that occurring? How is that happening?
It's occurring illegally, like totally illegally in the state level. I think we're seeing a bit of a cultural renaissance where people like prosecutors are not incentivized to go after these folks right now. We have an administration that's fairly friendly to psychedelics, which I think is cool. We have state governments that are friendly. We're kind of we're in the honeymoon phase of all of this stuff. And so I think people are not incentivized to go after them. There are places getting shut down. It's not like no one is, but there hasn't been the kind of aggressiveness towards it that I would have expected like 15 years ago. I don't think we can rely on that honeymoon period to last. If you start operating like a psilocybin sales warehouse, you very well might get raided. If you get raided, you don't really have a defense. There's none of these allow sales except for within the state regulated supply chains, which is very limited and not what any of these folks are doing.
Now, I'd say many attendees, right, or many folks in the psychedelic space, one of the fears is the uncertainty, right, of unknowingly crossing a line. So I'm curious to hear your take on like, what are some of the most common legal gray areas or misunderstandings that you see practitioners stumble into, even when they have the best of intentions?
Yeah. Okay. Well, the sales one is a great one, right? Like I have otherwise very well educated, very savvy, people pulling like investment money in, coming in with like well thought out business plans who are like, what do you mean I can't sell it? I'm like, you can't sell it. And they're like, no, that can't be right. Cause everyone's doing it, like they're advertising it like on streets in New York City. And I'm like, yeah, but they're doing it illegally. So that's a huge confusion. You can't sell it. Even in Colorado's personal use, you can't sell it. Some of these folks are relying on decrim measures to protect them. I don't think a real legal analysis upholds that. Decrim never protects sales or commercial activity. So people are using different justifications. And actually, I'll come into another one. People are using religious protection sometimes. They're like, oh, I'm a church. I've called myself a church. So now I can sell ayahuasca. I can sell psilocybin. And that there's a second huge bucket of misunderstanding there around how religious protections, RFRA, Religious Freedom Restoration Act, there's a federal statute. Many states have their own version, either in statute or through their case law of something folks have heard about this. It's real. You can have certain religious protections, but when those apply and when a court will uphold them to protect you if the DEA comes and raids your house or your warehouse, is really misunderstood. So if you're interested in, if you have a sincere religious belief and you want to be protected in your medicine use by becoming a church, please talk to someone who knows what they're doing there. Shakruna, colleague of mine, Allison Hoots, has put out a great guide. You can just Google Shakruna Religious Freedom Restoration Act guide or something like that. It's readily available. It's free. It's very generous of them to make that available. That has a great breakdown of the religious freedom case law and precedent in the country. And it's not actually nearly as friendly to churches as people would like to believe. You can't just call yourself a church and get away with a whole bunch. And I'm not saying that for all the sincere practitioners who really are doing this for religious benefit, but even for you guys, there are so many hoops to jump through to feel safe in that protection. That might be changing. If any of you guys are sort of nerds on this topic, look up the singularism case out of Utah. It's changed a lot of the laws around, or it's changed that court decision, which is a lower court, has changed some of the precedent about how a church can be entitled to religious protections. It's going to get put up to the 10th Circuit soon. I'm very curious what the 10th Circuit does. If it upholds the lower court's decisions, religious freedom laws might really be evolving in like a positive way, in a very exciting way. The 10th Circuit might say no way and go back to this huge body of precedent around religious freedom. But if you're interested in this church piece, singularism, go read some articles about it. Google it a little bit. It's a fun case.
And what would be the implications if that gets upheld? Because right now, I mean, I think this sort of church topic is a very essential one, especially for a lot of practitioners in this group who are not necessarily in Colorado or Oregon. But right now you have the UDV, the United Vegetal, the Santa Daime, the Native American Church. There's one other in Arizona, the Church of the Eagle Condor.
Condor, yep.
And then you have the singularism case. If the singularism case is upheld, will that make it much easier for churches to actually get sort of legal protection? Because right now, a lot of people think they have legal protection. Really, it's not truly legal.
Yeah, I think a lot of people right now that think they have legal protection would be in for an unhappy surprise if they were actually faced with criminal charges, and they would find that their religious protection probably doesn't protect them as much as they think. Singularism is an interesting case. It's not like it would blow it wide open and make it available to like 5 times as many groups as we have, that can benefit from RFRA type protections, but it does loosen some of the very, very stringent things that have been in historical legal precedent around that disqualifies someone from becoming a church. For example, sincere religious belief used to look at things like, does your religion claim to answer all the big questions of existence? Like, do you know what God is? Do you know what he or she wants? Do you know what you're supposed to do to have a good life? And a lot of churches, if they're honest, are like, no, we don't know those things. That's why we're doing medicine. And in singularism, they actually did that, which I thought was really admirable. And the court was like, yeah, props to you. I don't think that, the fact that you don't claim to be a prophet doesn't make you an illegitimate church, that doesn't undermine the sincerity of your beliefs. I think singularism is complicated because the government messed up a little bit in the sense that they tried to pretend that singularism was just like a sham to cover up drug trafficking. And like it very clearly wasn't. So I think the judge was like incentivized to rule in favor of singularism in ways that I really like. Singularism also had some like therapeutic clinical language sort of woven in there, which historically would have kicked, a court would have kicked them out of being a sincere religious practice or sincere church, based on most of the precedent. And that they didn't really, they didn't knock it out of there for that, which is very cool. But we'll see what the 10th Circuit does. It won't like make it like way more available, but it will make it more available in ways that I think are good for sincere religious practitioners.
So let's come back to this conversation for coaches, practitioners, especially those working in non-clinical formats, because a recurring theme in this work is the distinction between different roles. And you already mentioned this in terms of, folks in Colorado can't call themselves a facilitator if they're providing substances as part of a personal use or, as a gift, because that facilitator title is really reserved for those working within the regulated system of Colorado. So this gets into a little bit about language and distinction between roles. Can you help break down maybe some of the critical differences from a legal lens between coaching, facilitation, and therapy, and explain why respecting these boundaries is so essential for a practitioner's legal protection?
Yeah, great question. A complex question. Let's hold off. Well, coaching is the least regulated term, right? And you guys probably already know this. Coaching, it's not unregulated in the sense that if you call yourself a coach and you do things that look like therapy, we're setting aside the medicine piece, different states will come down on you as a therapist, for example. Like I know New York is fairly strict on this. But if what you're doing is actually coaching and it doesn't actually accidentally bleed over into therapy or psychiatry or something like that, coaching is the least regulated of these. Facilitation is a tricky word. It now means something very specific in Colorado. So it's been co-opted entirely for the regulated side. So you cannot call yourself a natural medicine facilitator unless you hold a Colorado license as either a regular facilitator or a clinical facilitator, which is someone who has certain secondary degree and has completed additional training to be able to work with high-risk clients. In Oregon also, they created a new class of profession called a facilitator. And until recently, therapists could not act as therapists during psilocybin administration sessions. Even if they were licensed facilitators, they could only act as facilitators. That's starting to evolve. And that now Oregon is starting to implement some of the dual licensure protections, the way that you have in Colorado, where you can be a therapist and a facilitator and do psychedelic therapy for real. Most places you don't actually want to call what you do psychedelic therapy, even if you're a therapist, because, and this is the new point, right? Therapy is the most loaded word, and it's loaded for a bunch of reasons. And the most significant of that is which scope of practice, like what you're able to do as a therapist ethically is a known thing, right? And it existed before plant medicine, and there's licensing boards in each state that determine what that scope of practice is. And almost universally, it allows the discussion of mental health treatment alternatives. It allows for education. So you could point to information out there about microdosing or psilocybin or whatever, if you're pointing to scientific studies, but it does not allow recommendation or sitting with someone while they're on medicine or facilitating. So that's really important to know. Like if you're encouraging the use of Schedule I substances outside of an approved state program, you're going to be out of the scope of practice if you're a therapist. And if your licensing board finds out about this, they're going to have problems with that. And that's true for psychiatrists. That's true for medical doctors. It gets a little interesting. Like if you are in one of these categories and you do want to talk to people about it, it's great to consult with a lawyer because, again, you want to be on the side of pointing people to good scientific evidence and not on the side of recommendation. You want to be on the side of disqualifying, being like, hey, I know you're on these medications. I would not recommend microdosing or macrodosing while on these medications. You want to be on the side of disqualifying. You don't want to look at someone and be like, you seem like a fantastic candidate, like give you the green light, go do a bunch of psilocybin. And it interacts in interesting ways with these sort of like medical free speech laws that I won't get into in too much detail here, but we saw in cannabis. Like when does a doctor have the right to sincerely recommend cannabis? It's an interesting question. It's not super straightforward. It's fact specific.
Well, and I'll just kind of say something here, I think, because it's come up a couple of times. I think for all practitioners who are on the audience and those who are, considering stepping into this role, really the role of a coach is to elicit agency out of the client that we are working with and help that client to become, have more agency and feel like empowered and feel capable of making their choices and decisions that are actually best for them. And I think one of the best pieces of advice I got many years ago from those in the psychedelic space is people shouldn't feel obligated or feel like they're sort of being forced into working with psychedelics or plant medicine because of the intensity. And really people need to come in to this decision on their own. And you as a coach or support system in their life is there to just ensure that if they are really wanting to do it on their own, that they can do it safely and effectively. And it can actually support their well-being and not potentially, cause any sort of harm in their life.
Agree totally.
So just to kind of bring us back to the sort of point that we were getting into, this distinction between coaching, facilitation, and therapy is pretty essential and pretty critical. And to me, this also gets into the ethics of what we're doing, right? And so I want to transition our conversation there. I'm just mindful of time, Barine, and want to make sure we have some time to cover ethics. Because when the law is unclear, ethics become even more important. So I'm curious to hear sort of your take as both someone who worked in research with psilocybin and now someone who's been at the front, sort of had a front row seat for law. and policy, like what does an ethical framework for client screening, preparation, and integration look like for a coach practitioner who is committed to working with honesty and care?
Great. So, okay, you need to screen. Please, please, please screen. Screen in writing, like have a written piece of paper or an online form that the client goes and completes. Don't like do an interview and kind of check your own boxes and complete your own screening form. Have the client complete a screening form. If you don't know what should go in a screening form, you are probably not ready to work with people yet. Please go get more training. Every once in a while, I'll have a client, like a potential client that comes in and says, what should I screen for? I'm like, your problem is not the legal documents. Your problem is that you're not yet ready to do this kind of work. So know what you need to screen for. Screen diligently, screen more than you think you need to. This is kind of, if I had to offer like one piece of advice for everyone for avoiding disasters in their psychedelic practice, it would be that. If you're taking every single person that comes to you, you're doing something wrong and it's going to come back and bite you at some point. So please screen. Psychedelics are not appropriate for everyone. What you think who you think they're appropriate for, and who I think might be different, and that's okay as long as you're educated and informed. But you need to be screening. Also, please use your intuition to screen. You guys, if you do this work, you'll develop a really highly attuned intuition. You won't always know why you don't want to work with someone, but please trust yourself when you don't want to. You're already providing people with a level of care that they wouldn't be able to access without folks like you. And you guys are already taking some personal risk to do this kind of work. You don't need to take extra. You don't need to see every single person that shows up at your doorstep. Some people aren't for you to help. They can get help in other ways. But if your intuition says no for some reason, please learn to trust that. Most often, I think literally every time I've had a guide come to me or a facilitator after they've had a bad experience with a client, they've always said some version of, I knew this wasn't exactly right for this person, or I didn't really want to work with them, or I had a bad feeling about it, but they really seemed like they needed the help. So I went for it anyway. I wish I hadn't. And those cases where something is wrong and the client has like a really bad experience or is threatening some sort of to report them to the police or to sue them in civil court, it's so stressful and like borderline traumatic for the facilitator or the guide. It's an awful experience. And I know a couple guides that don't want to practice after that. So like take that seriously. When your intuition says no, you can ask it why in the sense of cultivating and learning more about yourself and learning what risk factors you're picking up, but please trust it. You'll be happy you did. So, okay, screening, like screen a lot. You have to prep. And if you're in one of these states like Oregon or Colorado, there's going to be prep required by law on the regulated side. But even if you're not and you're only doing harm reduction, prep at least one, maybe multiple prep sessions, maybe with some people, 10 prep sessions. You have to build a trust container that can survive difficult experiences during the journey. And this is further time for you to cultivate your intuition too, and further time for your intuition to say, no, wait, that's a red flag. Oh, no, wait, maybe I need to ask more questions about this. So please prep more than you think you need. You guys will all know how to prep by the time you're trained, but please, do a good job with preparation. Don't skimp, and don't skip on integration. Really don't skip on integration. There's one person, I keep wanting to credit her, but I can't remember her name. She says there's no such thing as a bad trip. There's only an unintegrated trip. I'm not sure I agree with that fully. Like I've sat with this a lot. It's become a little bit of a koan for me. But there's definitely a whole chunk of things that would not be bad trips if they were integrated, right? So you don't want your clients having bad trips. You don't want them, out of compassion and care for them. And you also don't want them having bad trips for your own experience. So get them integrated. And if for some reason they can't integrate with you, they had a bad experience, the trust container was broken, some trauma was triggered, you messed up a little bit, something happened and you can't integrate with them, please make sure that you have a referral network of other people that you really trust, that are not brand new to psychedelics, that aren't going to think you're a terrible person for, doing harm reduction, but like understand this space that you can refer them to. So you can hand them a list of like, hey, I'm so sorry that we're not able to integrate this experience. These 3 people are great. Please go talk to them. Please pick one of them and go integrate with them. Like have peers and colleagues that you trust. Also, don't try to save money on integration. I keep hearing like clients complain about their guides because they had a prep and integration session and the normal session, and that was all part of some package deal, the harm reduction session. And now they're like, oh, well, they wanted more integration. So I told them it was going to be $300 an hour. Like, don't do that. That's not where you want to save your money. If someone's coming to you and they still need integration and you can tell that they're in trouble, you can tell that they're struggling, just help them out, help them out as like a fellow human being, and it will save you a lot of grief in the end. And I think it's the ethical thing to do. So don't try to make integration your big money maker.
I love that. All good advice.
Yeah. And, there's stuff that we can talk about in the forum. Be really, really deliberate and mindful and like over engineer your process, be like, I'm going to touch you on the feet and the arms. Is that okay with you? Get it in writing. If they don't want to be touched at all, get that in writing. If they tell you they don't want to be touched at all, and then in the middle of the session, they're like, actually, I really want a hug. Be like, you know what? I have so much care for you right now, but I can't give you a hug. You told me beforehand, you had this boundary. We're going to respect that boundary. Be really deliberate, be really, mindful, be really precise in your work. Psychedelics are not always a precise space, and that's okay, but you can still hold a very precise and in integrity container around that. And even if it feels right to do something that they didn't want you to do beforehand, and you really believe that they sincerely want a hug, if they told you beforehand they don't want to be touched, just don't touch them. You know what I mean? Like, offer them a pillow and some essential oils or something like that. But like, you can build a very precise container around work that's naturally sort of chaotic.
Beautiful. Beautiful. All right. Well, all right. So this is all helpful context. And, Barine, when we were thinking on Monday prior to stepping in, I knew we'd not have time to address every question. So let's get to Q&A. I'm going to pull down the slides. I think the first question that I'm seeing quite a bit of, Barine, is around kind of coming back to the sourcing question, because I feel like we didn't fully integrate that. So a lot of folks, will have clients who come to them and say, where can I actually source substances or find substances if I want to do this, which obviously puts practitioners in a difficult position. How can coaches and practitioners navigate that conversation in a way that's ethical, safe, and legal?
Yeah, great question. And no one likes having to ask this question because everyone wants to be able to send their clients to a safe source, which I understand. But let me talk really briefly about the risks of doing that, right? So if you are like, hey, go to this person, they'll sell you mushrooms, or you can get mushrooms from them, then the risks are you're aiding and abetting the drug trafficking, the sales, the possession of a controlled substance. And that's both a federal and a state level crime, potentially, right? So that's the worst case of what people can come after you. Aiding and abetting a crime can be just as bad. The penalties can be just as bad as committing the crime yourself. So there's also a conspiracy. There's other sort of, depending on how it's all set up, you could just be part of the drug trafficking ring. These are all crimes that could be brought against you, charges that could be brought against you. And they're criminal, they're serious. So don't do that. And then the other set of risks is in Colorado, and I know in other states that it exists and it looks different, but there's something called a referral liability. And this is completely independent of medicine. If Paul came to me and said, hey, give me the name of like a really good dentist, and I was like, I've got just the dentist for you. Go to this guy. He's fantastic. And then this guy doesn't know what he's doing. He messes up your teeth, whatever happens, you actually could have a civil suit against me, depending on the facts, for referral liability that I negligently referred you. So even when you're referring someone to just another coach or just another therapist, again, setting aside the plant medicine, it's good practice to know your state's laws about referral liability, and also to refer them to more than one person, right? To refer them to 3 therapists and say, hey, talk to one of these 3 people. And then they can make their own decision. So that's just good practice. Generally, with medicine in particular, referring someone to a source has the far more serious criminal consequences possible, but it also has civil consequences as a possibility, like referral liability. So don't do that. Instead, what we tell people to do is, if you can refer someone to a community, then that's good, right? In Denver, for example, we have some great community of psychedelic practitioners. There's all sorts of student groups. If you live near a university, there's meetup groups. There's, what I mean? Like there's online groups, there's Third Wave, there's really good groups like Third Wave. So there's a lot of places that you can refer people to online, locally. So it might be good to just send people to a community of people that are interested in this type of work, and not touching the source piece at all. And again, ideally, your clients are well educated on what is safe dosing, safe sourcing. They know what kinds of questions to ask. If they're well educated, they might know to ask whoever their source is, like, oh, has it been tested? Like, where is it grown? How do you know it's not got contaminants in it? How do you know if it's an extract? How do you know it's stable? Maybe they can educate themselves through education sources and these communities to ask the right questions. I know that's not a very satisfying answer for a lot of folks, but I think that's the safest way to go.
And I love that lens as well, because that's what I tell some folks. I'm like, oh, just we have a community on Third Wave, even online. Like, tell folks to go to Third Wave's community and start to meet folks, even online, who may be able to connect and help them out. And there's a lot of meetup groups as well in terms of psychedelic societies. And it's a bit of a tricky thing, because you don't want to be the guy who's just, or the girl, the woman who's just showing up at a random event and asking around about mushrooms. So there is definitely like a relational element here that I think is really important, that this is about relationship building. And as you know, again, this is not legal advice, and Barine may slightly kind of do this when I say this, but we live in this sort of very open time now, and I think that's the most important thing with navigating all of this landscape is don't go in blind, ignorant, or naive. Really know and understand the law, and if you choose to step over a line, make sure you're understanding the potential risks and consequences of doing so. And I think that's also an important aspect and an element of this work with psychedelics in particular.
I love that point, Paul. I think that's super well articulated. Like, nothing I'm saying should be said to tell you guys what to do or what not to do, right? That's not my business. I'm not law enforcement. I can tell you what we as lawyers are ethically allowed to help with, and I can tell you to the best of my ability the consequences or the potential risks of doing things. Otherwise, I mean, do what you think is right. There's an entire underground practice universe that we benefit from, their experience, the risks they took, the things they learned all the time. This research wouldn't be happening without people doing this stuff illegally. So none of this is a moral statement, just trying to get you guys to understand the risks and do what you feel is right from there.
So I have another question from Robert, who's one of our alumnus and a great dude. And I think this is a good question. Given the nature of possible litigation or high grief from a client who did not get the experience they were hoping for, would it be better to focus more on the absence of written agreements that make any mention of psychedelic use? As an attorney, you know better than most that the burden of proof must be beyond a reasonable doubt. While I would not want to protect or hide individuals with poor skills or intentions, it feels like having less ammunition for those who might want to ruin those with professional credentials or otherwise civilly damage a practitioner.
Oh, it's a great question. I would tell you guys to try to operate legally, right? So if you're in a harm reduction area, like if you're not in Oregon, Colorado, or New Mexico, work under harm reduction, don't provide the medicine. If you're in Colorado and you're operating under personal use, operate properly under personal use so that you can benefit from its protections, and then document what's actually happening. It's not realistic that someone's going to be able to say, I had a really bad 5-hour journey, and you're going to be like, you were stone cold sober the whole time. Do you know what I mean? Like, not documenting it might be the thing to do if you're in the underground. Again, as a lawyer, I'm not ethically allowed to tell you guys what to do if you're operating illegally, but if you're operating legally, or at least with a colorable argument for legality, which harm reduction is, then I would suggest you properly document stuff, because you want things for example, your client's screening doc it's going to be very clearly psychedelic focused. And you're going to want them to tell you in the waiver document that everything they've said in the screening document is accurate and up to date. And if any of that changes, they'll come let you know. So you're going to want things that protect you in that documentation too. So it's not just for the client's benefit.
Beautiful. Well, Barine, there's never enough time, especially with legal questions. I just want to express my appreciation and gratitude for you joining us, sharing so much of your wisdom and knowledge with everyone on the call today. So, folks in the audience who are still here, if we could give say a big thank you to Barine. If you are, wanting to dive deeper into this, we already mentioned the training program. I'm going to pull up Vicente's website as well. I'd also encourage you to go check out what Vicente is up to. And if you are needing support on how to navigate this and you're looking for legal help, they are the best in the game when it comes to all of this. So check out what Vicente is up to as well. But this has been fantastic. And I think at some point I'd love to do a round 2, because it feels like, no matter how much time we have, there's always more questions. So I appreciate you joining us today, Barine.
No problem. Always love joining you, Paul, and your crew. So thanks, everyone.
All right. Thanks, everyone. We'll see you next time.
Take care.